This is an online solution where you can create your estate planning documents without the assistance of having to take time off work, your spouse take time off work, and then you go in and you sit in a law office and you spend 2, 3, 4 hours in there getting your estate planning documents done. We cut that down to about a 20-minute process by our software. That's what NetLaw is. NetLaw is a online solution that you can create your estate planning documents online. It's a DIY process, but you have the support. The software's been created by attorneys in every state. So it doesn't matter where you live or where you move to in the US, you can use this software to create your estate planning documents. And when you're done, you receive the same exact documents that you get as if you went and sat in front of an attorney's office, because remember, the software was created by attorneys for you so that you can complete these documents. And at the end, you have state-specific legal documents. So I'm not going to go over this too much, but NetLaw is the only estate planning law firm to win the James Keene Award from the American Bar Association. I bring that up because it's very important. That award is given out each year to the company that has the best online delivery of legal documents. So we are the only company to win that award by the American Bar Association. So when I talk about that award, I talk about who hasn't won that. And it's companies, LegalZoom, Legal Shield, Trust and Will, Rocket Lawyer, right? These companies that spend millions and millions of dollars on advertising still haven't won this award. The best online delivery of legal documents, NetLaw is the only one in estate planning to win that award. So I always talk about, we have a full understanding, and we've heard this millions of times, of why estate planning is so important. But really, as Kishore knows, I have broke this down into 4 segments. One is who's going to get your assets, right? That's what we're all worried about when we create our will and our trust, is making sure that everything that we've accomplished in our lives, every asset that we've accumulated, gets sent to the next generation, our spouse and our kids, right? Making sure that they receive everything. And without a will, it leaves it up to the government to decide how our assets are distributed. And no one wants that, right? No one wants government interference. But when we have our will and trust, we make sure that all of our assets get distributed to the correct beneficiaries. The second reason we do it is our children, right? If you, on this webinar, if you are a parent of a minor child or children, having that will is important, because we're going to name guardians and we're going to name alternate guardians. If something happens to me and my spouse, who's going to raise our kids? Who's going to be in charge of their inheritance, making sure that what we do with that inheritance goes to the kids and make sure that it's in their best interest? Very, very important. And this is the first thing when clients come in to me and I know that they have children under the age of 18, this is the first thing that I talk about. I talk about what happens in the unlikely circumstance, but it happens every day, if both spouses pass away and they still have children under the age of 18. First thing that I talk about is making sure that we protect our children. That's our number one goal as parents. 3, avoiding probate. Probate to me is a 4-letter word. That's bad, right? We all know that 4-letter words are bad. So we want to make sure that we avoid probate. Probate is the process where if you don't have a revocable living trust and you don't put your major assets inside that trust, so that the trust is the ownership of your home, cars, bank accounts, boats, vacation homes, anything that has a deed or a title attached to it, we want to make sure that those items are owned by the trust. The trust is the only document that we have that avoids probate. But probate is the process where when you pass away without a trust, all of your assets are frozen by the government. And that gives creditors time to come in and take what's owed to them first. Then what's left over is passed to your beneficiaries. But if you want to avoid the probate process, having that trust and funding those major assets into that trust, very, very important. And the last reason we create this comprehensive plan is you have 3 medical documents inside this plan. And you have your medical power of attorney, your living will, and your advance directives. All of that, along with a HIPAA authorization, is included in this plan to not only take care of your financial decisions, but also your medical decisions as well. So very, very important. So once you get signed up with this, this is all the documents that you receive, and we're going to go over that in just a little bit. But all of these documents here are included, and you can see there's your will and a children's trust that's included inside the will. We'll talk about that in a little bit. Your financial power of attorney, the 3 healthcare documents that I talked about. We even have a pet trust and a revocable living trust. All of those documents are included for our $600 price. But all of those documents are included for you and your spouse. So both spouses get to create their documents for price. It also comes with a life vault at the very bottom, third from the bottom there. A life vault, it's called My Files. And what that is a place where you can store all of your important information in there. The vault is very important. That life vault is very important because not only can you store, once you create your documents, you print them out, you get them witnessed and notarized, and you can store all of those documents back in your My Files. Not only your estate planning documents, but you can store anything. Deeds to houses, titles to cars, bank account information, tax information, pictures, videos, anything that you want to store there, because this vault system, which is called My Files, has over 100 gigabytes of data. So you should never run out of storage space. You can store everything that's important to you in one spot. So not only have you created your estate planning documents, you've printed them out and you've stored them, you can store everything else that's important to you as well. Second to last option there, spouses plan is included. Like I said, both spouses get to create their documents for one low cost. And then we always have a 30-day money back guarantee. If you don't like it for any reason, we'll give you your money back as long as you haven't downloaded your documents, but no one ever uses that. This is the state-of-the-art attorney-backed program. So very rarely, I mean, 1 in a million do we give a refund back on. This is the last screen, and then I'm going to show you how easy it is to use the system. This is why we do estate planning. These 4 reasons. It's personal, right? We want to make sure that everything that we want to happen, happens. It's very important for us to make sure that everything that we've accumulated gets passed to our beneficiaries. Second reason there, conversational. I put that in there. Please, 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 when you create this, please let somebody know that you created these documents. Let them know that, hey, I've done my documents, and if anything unexpected happens to me, here's where you can find them. Here's who's in control. Here's the guardians of my children. Here's the executors of my account. Here's my trustees. Here's everything, right? So let people know. Digital, right? We're an online estate planning law firm that is a IT company as well. It's digital. You can get into your account 24/7, print out your documents, edit your documents, do whatever you need. And then done. I put this as the last talking point. 60% of Americans don't have a will. That's from a Bloomberg report. It's not our numbers. It's from a Bloomberg report that came out not too long ago. 60% of Americans don't have a will. What's even scarier is 90%, 90, do not have a full comprehensive setup. The plan that I just showed you is the full comprehensive plan. We're here to serve you. Be able to go ahead and create your estate planning documents, and we're to help you to do that by our online service. We have a full customer service area that if you have any questions, there's a chat bar in your plan that you can click on, and you can talk to us from 8:30 a.m. to 8:30 p.m. Eastern Standard Time. So with that being said, that's kind of a little bit about what NetLaw is and why we're actually doing this. Let me share I'm going to get rid of this here, and I am going to bring on my NetLaw plan. I'm going to lower this. Give me 1 second to bring this back up. Here's what, so when you get the plan, this is what it looks like. This is your profile page. So as you can see on the left, we're going to deal with 4 line items. Over here on the left, my profile is exactly what you think it is. It's just information about you. When this page pops up, this is going to be blank and you're going to fill it in. First and last name, your full legal name, male or female, and birthday. Then it's going to ask you, where do you live, right? I live in Kentucky, so I put in all of my information. Real easy information, right? This is not hard to do. Your shipping address. If we ever need to ship you anything, is your shipping address the same as the residential address that you put in the file? Yes or no? That's it. It automatically takes you over here on the left-hand side to family and contacts. That's our next plan. And you create all of your contacts. This is everybody who's going to play a role in my documents. How did I add these people? Down here in the bottom right. See this little circle right here with the person in it? You can just click that. Spouse, child or children, parents or others. Let's add one real quick. I'm going to just click other and I'm just going to make one up. I'm going to make Tom Smith. He's a male. His birthday is 1970. 1970. And relationship. Let's just say he's my cousin. So I start typing that in. Cousin. And then I'm going to scroll down on the page, get the rest of the thing. It's just going to ask me where he lives. So let's just say he lives in Nashville, Tennessee, right? In the US. And I can hit finish. There he is right there. This is everyone who is going to play a role in our documents. This will make sense when I show you the next screen. So once we've put in everyone who's important to us, everyone who's going to play a role in our documents, we come over to Smart Guide Interviews over here on the left-hand side, and we just click that. This is our active plans. We're going to go down under property and guardianship, and we're going to click last will plus living trust. This here has my name and my wife's name. So our spouses are all going to be here. We're going to create my documents because this is where the check mark is. If I wanted to create Donna's, I just click on her name, and now we know we're clicking hers because the check mark's there. So let's go back to mine. When you first get started, this is going to say start. If you ever come back to it, it's going to say edit. This is my pre-populated test account for you guys. So you don't have to sit here and see me type, which is not good for anybody because I'm a slow typer. But as you come into your plan, it's going to ask you everything as if you came into a law office. You sat down at the big oak table and the attorney's going to sit there for hours and ask you questions. So executor, here's the executor. First thing that's asked about, who do you want to be your executor of your account? Over here on the right-hand side, you can see frequently asked questions. All of these frequently asked questions are there to help you understand why you're filling this document out. How did I pick Donna? I just click on the box. All of my people who play a role, right? I can pick it. I can name multiple people. If I wanted to name Donna and Ashley, I could do that. Or let's say I wanted to take Ashley out. You just click on it, take her out. Now it's just Donna. And we click next. We always have successors or alternates, right? If Donna can't fulfill the role, then who's going to fill her spot? The great thing is we can name multiple people serving together. That means they all have to agree, or multiple people each serving one after another. That means the first person you name is first. They get all the decisions. If they're unavailable, then it goes to the second person, then the third, then the fourth, right? One successor or none. I always keep it easy and name one successor. If I ever wanted to change Bob, I could name Tom Brady, or I could just go back in and name Jacob, right? Doesn't matter. Whoever you want it to be. And you click next. Then it takes you to guardianship of minor children. Remember, that's what I talked about on one of the things that was so important about doing this. Again, we're talking about guardianship here. Again, same thing. You can take Jacob out, Ashley out, and I want to name Bob Smith. There he is. And you always have successors. So if Bob's unavailable, I can name Bob Allen. So that's the executors and the guardians. Now we're talking about the trustees of our account. You are always the trustee of your account as long as you're alive. But I can also name my wife. There she is. Now, we're both the trustees of my account. The trust will be in my name, but we're both trustees. If something happens to her, maybe she passes away, I can always take her out, or I can add someone else. And then down here, multiple successors serving together. These are your successors. If Donna's unavailable and I pass away, you can name one successor or multiple. On this one, I chose multiple, but it's totally up to you what you choose. There's no right or wrong answer on this. It's whatever you feel is best for your family. We can create a pet trust if you have any pet. Most people say no. Device of personal residence. Yes, I want to do that. Here's my address. Here's where I live. And then when I pass away, how do I want my property to be distributed? At my death, only if my spouse does not survive me. That means usually husband and wife are on the same deed, right? So if the husband passes away, it's still the wife's property and vice versa. But this is for when the second spouse passes away. How do I want it? At my death, only if my spouse survives me. And down here is where you name your beneficiaries. You click the add button and name your beneficiaries. And if you ever move, you can click yes to this button, replacement property. If you ever move, you don't have to log back in here and change your address because you're saying, wherever I live at, I want that address to replace this one. So we've made it as easy as possible to keep your documents up. If you own other real estate besides your main property, you can add that here, as I did. You just click the add button. Parcel details pulls up, and you can put another one in there. Say, let's say 200. Oops. Yeah, you can put properties in here from other real estate. So how do you do that? You click add. You can click the parcel details. Let's say I'll try to put one in. 200 Main Street. I'm just going to make up a city. Baird, India. And you'll scroll down. Oh, I spelled India wrong. See, this is why no one wants to see me type. And then effective date. When does the house in India get passed? At my death only, or at my death, whether my wife is alive or not. So I may want to leave that house in India to my kids who still live there or move back there, right? So very, very important. So you can just pick that one. And then click next. This is so easy to do, guys. Then you have specific bequest. Get this out of the way. Specific bequest is I want to leave a certain asset or an item to a specific person. I just don't want everything to go to my spouse and to my kids. I want this particular item to go to a particular person. That's what specific bequest is. You just click add. And it's the same way, right? So you scroll down because I've named a lot of them. Individual. And then the beneficiary's name pops up. And let's say I want to leave Ashley, let's say an item. How about a Rolex? And then when does she get it? At my death, regardless of whether or not my spouse is alive or not. That adds it into the system. And then it says here. Now, everything that I didn't list in specific bequest, that's your residuary estate. Everything that I didn't list in specific bequest, everything else, how do I want it distributed? All to my spouse, if alive, then to my children, or all to my children, whether my spouse is alive or not. Or you can name it, you can give it to another person or a charity. Good thing is if you have any children that you want to omit, maybe they left the family or they may have a drug or alcohol abuse, something like that. You don't want to give them any money because you know where it'll be spent in a bad way. You can omit children Or you can leave a descendants trust where this is really for people under the age of 18, right? When we talked about the guardians and the children's trust, this is exactly what it is. So we have 4 options where you can leave your inheritance. If you and your spouse pass away, when do you want your children to receive their inheritance? If you click no here, they're going to receive it all at age 18. That's in every state. But a lot of parents say, 18 is a little too young. Let me see my options. And these are the 4 options you have of when your children will receive their inheritance if both parents pass away before they're the age of 18. And you just choose the one that's best for you. Ultimate disposition means that you outlived your spouse and kids. Now, how do you want your assets to be distributed when you pass away? You can leave them all to your heirs-in-laws. That's usually your next closest living relative. Or you can split it between yours and your spouse's next closest living relatives. Or again, you can name a person or a charity. Most people click my heirs-in-laws. That's just the way it is. You click finish. You just created your will and trust. Your will and trust was just created. It's saving it here. As you can see the blue line going across the screen. And when that's done, you can click go to my files. And here's where all of the documents are stored at. This is where you're going to print each document. And you print them out and get them witnessed and notarized, right? You go back to Smart Guide interviews after that's completed. And remember, you have your healthcare documents and your power of attorney that you can create as well. It's that easy. Seriously, it takes about 20 to 25 minutes for both spouses to create their estate planning documents now. If you come into our law office, you're going to be there a minimum of 3 hours. Once you create your documents and you're in your My Files, like here's Donna's healthcare directive. So we can click on that. I'll show you what the document actually looks like too. But you want to print out each of these documents and take them and get them witnessed and notarized. Very, very important. So it's downloading. Also, while that's downloading, this plus button in the bottom right here, you can create a folder where you can store, like I've created this tax folder at the top. So you can store all of your tax information in there, like when I was talking about the values of the estate plan. You can do that. And you can upload your files. This is how you upload your signed, notarized, and witnessed documents. You can just click that and slide your documents over. These are legal documents, guys. This is exactly the document that you would get. This is my will that I just created. So this is a legal document. This is exactly what you would get if you came into our law office. Everything is here. You can see that it's a long, drawn-out will. So we're not skimping on anything. This is a full legal document. That's where your witnesses sign, and here's the notary. So it is a full attorney-backed document. This isn't a cookie cutter plan where you get one page and you got to write a lot of stuff in. This is a full comprehensive plan created by attorneys. The trust to me is probably the most important document we have here because the trust is not a document for us. It's a document for our beneficiaries. Because when we pass away, everything that we've put into our trust. Now let's talk about funding the trust, because a lot of people think that once they create the trust, they're done. You're not done. You still need to fund that trust. And what I mean by funding is changing the ownership out of your name of an asset. Let's say your house. Right now for the house, you have a deed, and that deed is in your individual name. What you need to do is go down to the county clerk's office and tell them that you want to put your new deed, you need a new deed, a warranty deed or a quick claim deed, whatever they call it. It's the same thing. But you want to change that deed out of your individual name into the name of the revocable living trust. That way the trust owns the document or the property instead of you as an individual. Now, why would you want to do that? Because that is what avoids probate. Remember, we talked about probate and freezing of the assets and not being able to transfer those assets right away. A trust is the only document that will avoid probate for your beneficiaries. That's why it's so important. Major asset, anything that has a deed or a title attached to it, like a car, house, bank account, boats, vacation homes, stuff like that. Life insurance policies, 401k, IULs, they don't because they already have a named beneficiary, so they'll pass automatically. But any major asset that you have that doesn't have a named beneficiary needs to be in the trust. You know, anyone who's making as a family $22.5 million or less, you don't have to worry about taxes. There's no estate tax on estates that are under the 22.5 million. That's a President Trump law that's still in effect right now. So if the estate is under $22.5 million, there's no estate tax.